Its sister organization, the MLRC Institute, is the group that's putting on today's legally oriented sessions under a grant from the Knight Foundation. Knight gave us a 3-year grant to go around to journalism conferences around the country and talk about media law topics to people who don't necessarily have this kind of advice and this kind of a background on a regular basis at their organizations. This is going to be, the first session is going to be talking about libel and privacy law. It's going to go for about an hour and a half. It will be the first of 3 sessions today. You are not obligated to attend all 3, although we certainly hope you do, or at least are interested in some of our other sessions as well. The second session is going to be on copyright law and digital media law, and the third session will be on media insurance, a topic which I know is of great concern to a lot of people at this conference. With us today to talk about, libel and privacy are my colleague George Freeman, who's the Executive Director of the Media Law Resource Center, and Natalie Spears, who is with Dentons here in Chicago, a very experienced attorney on these issues. And with that, I will be quiet. Is there anything else, George, you wanted to say before we begin?
No, I'll just say that we're a fairly small group, and if you have questions about something I'm talking about, feel free to ask your questions contemporaneously. We don't have to wait till the end of the session. I'm going to mainly talk about libel, which is, I think, unfortunately, the place that journalists and lawyers meet for the first time when you've either been sued or threatened with a lawsuit having to do with libel or defamation. By way of introduction, I just would mention that I use the words libel and defamation interchangeably, and the reason for that is that defamation really is the umbrella term that includes both libel and slander. The difference between libel and slander is that libel is speech that's recorded. And since everything in the media is basically recorded, whether it be in print or on tape, but radio, TV, magazines, books, digital, it's all recorded. Really, when we're talking about media law, 98% deals with libel and almost nothing deals with slander. So that's why I use libel and the umbrella term defamation basically the same. There's no real difference. So what I'm going to do is talk first about what a plaintiff has to do to make out a libel case, when he has really the opportunity of going to court with a reasonable claim, and then talk about what the defenses are that we in the media use generally to win those cases. And they're either the old, what we call common law defenses that were, a residue of British law, 300 years ago, and more importantly, constitutional law, because in 1964 in the well-known New York Times v. Sullivan case, the Supreme Court basically constitutionalized libel law, said it came under the First Amendment and therefore essentially made it much more difficult for plaintiffs to sue because, as the court said, there's a First Amendment interest in robust, wide-open debate on public issues, and therefore they made the law very different than it had been and very different than it is even today anywhere else in the world. Our constitutionalization of libel law has made our law more protective for the media, by far more protective than really any other country in the world. Which is why I say I worked at the New York Times for 30 years, and during those 30 years and beyond, the Times never lost a libel case or settled for dollars. But I can't say that we never settled for money, because we've settled for euros and for pounds and for rubles, because over abroad you don't have the kind of defenses we have here, so it's really much harder to win. But we've never lost or even settled in the U.S. Because of the extra protections we get. And, that's not to say that our law is better as a matter of public policy. There are a lot of public figures, one I can think of in particular, who just started a new job yesterday or 2 days ago, who thinks, I think, that the law is too protective for the media. It is what it is, and one can think about whether the law elsewhere makes more sense or not. So I'm going to start by talking about the elements that a plaintiff has to prove to make out a libel case. And the first one sounds awfully easy and basic, but it actually is not quite as fundamental as it seems. And that is that libel is a false statement of fact. Now, in that very, very easy definition, there are 2 concepts, both of which are a little more complex. First of all, falsity, right? The gravamen of libel is that it'd be a false statement. What do we mean by falsity? If I say that Natalie robbed the bank of $12,000, and in fact she robbed the bank of $10,000, I've said a false statement, right? Falsity seems to have been, that element seems to have been met, because I was wrong.
I would also probably try to take a lot more than 12.
But that might ruin my hypothetical.
I think it's defamatory that way.
If in fact she had truly robbed the bank of 10, and I said $12,000, and she sued me, I would win right at the outset, because my statement is, quote, substantially true, which means it's not false, even though it really is false. And by substantially true, we mean that the perception that you have about her, the gist that you have about her, is not any different than the reality. So, you know, you might not think you won't think differently of her, whether it's 10 or 12,000, it doesn't really matter in terms of your perception of her, and therefore she can't sue on that basis. Now, on the other hand, if I call her a felon, and in fact she was convicted of a misdemeanor, that probably is different. That's kind of a difference in kind, and she would have a right to say, hey, that's false, and your perception, the reader's perception of me is different, because you know, felons are like serious criminals, and I'm just a lowly misdemeanor type person. So, you know, I can't give you more guidelines than that, but the guideline is really, does it matter to the reader? Is there a different perception in the reader because of the falsities? It has to be that false to create a different impression. And the second part of that definition, false statement of fact, it has to be a fact. And it's very unclear and kind of metaphysical what's a fact and what's an opinion. But the Supreme Court said in so many words that there's no such thing as a false opinion. And if there's no such thing as a false opinion and falsity is required, that means that all opinions are protected. So the only question then is what's a fact and what's an opinion? If Natalie were to write in her essay that she sends to all the lawyers in Chicago, I was with Freeman at this Lion conference and he's the worst lecturer I've ever seen. Is that a fact or an opinion? And the answer is it's not all that clear. I mean, that different judges could come out differently. It might depend where she wrote it, what the context was. If she gives a few examples, Freeman is the worst lecturer because he didn't wear a tie and he talks with a New York accent, well then the reader has something to go on, and the fact that I'm the worst, you can, as a reader, can agree or disagree, and that makes it more into an opinion or a conclusion. But if all she's giving you is he's the worst, then maybe you can't really disagree, and therefore it's not really an opinion. So my point is not to really hone down on exactly where the line is, because it's a very flexible line, but just to understand that if it's an opinion, you can't sue on an opinion. You know, the Chicago Symphony is the worst big symphony in America. That really sounds like an opinion, and particularly if it's in a review, whether it's in an editorial, whether it's in an op-ed page. That's not determinative, but that still will kind of point you towards you're looking for opinion in those places, as opposed to a news article where you're looking for straight facts. So that's what we mean by false statement of fact. Second requirement is that it has to be other concerning an identifiable person or entity. Okay, which means it has to be about someone who we understand, you know, can sue, and someone who we can really realize is the subject of the negative statement. For example, there was a case in New York once where W.R. Grace, who was the CEO of this huge conglomerate, the Grace Company, said that Puerto Ricans in New York are on welfare. And the Puerto Rican Defense League sued. But the court threw the case out because, as stupid as a statement as that was, you couldn't say that that really applied to every Puerto Rican, so you didn't know who it applied to, so therefore it really wasn't of or about a particular person. And the case got thrown out. Similarly, if you say New York policemen take bribes, there are 30,000 policemen, and Sergeant O'Sullivan can't sue because who's saying it's about him? On the other hand, my little town in Westchester County has 8 policemen, and if you say Pelham policemen take bribes, Sergeant O'Sullivan of the Pelham Police Force could sue because the group is small enough that he could say, hey, that's about me. And the borderline there is about 25. But also the person doesn't have to be named. Let's say I say that Northwestern's quarterback did cocaine the morning of the game. I didn't mention who he was, but we all know who the quarterback is, and therefore he's identifiable, and therefore he could sue. So the answer doesn't hinge on whether or not you name the person, it's whether or not he's identifiable. Okay? So that's the second element, that it has to be an identifiable person or entity. Companies can sue, partnerships can sue, so it doesn't have to be an individual, but it has to be an identifiable entity. Thirdly, and this gets a little more, this gets a little more complicated, is the theory of publication. And by publication, we mean that it has to be published, the statement has to be published to a third party. So if I take Natalie out in the hall and say, Natalie, I'm really disappointed to learn that you plagiarized that paper. Have I libeled Natalie, assuming it's not true? The answer is no, because I've just told it to her. Her reputation is going to be lowered, and defamation is all about reputation, because no one else heard it, and she's not going to have lowered her own. You don't have a reputation in your own mind about yourself. It's what a third person thinks of you. On the other hand, if you guys walk by as I was saying that, then she could sue, in this case, for slander, because it was published to a third party. You all heard it. You think less of her as a result, and therefore she could start the beginnings of a libel case. So that's the easy part of publication, that it has to be published to at least one third party. The more complicated part of a publication is the concept of republication. So let's say that I see Natalie on the corner, and she says, you know, your colleague Jeff Hermes, I'm disappointed in him because he plagiarized that paper that you put in the MLRC report, and that's really, you know, he basically is a liar and a fraud.
I've now been libeled in 7 countries across the country.
And so she gives me her name, and I put that in my newspaper with quotes. Natalie Spears said, quote, Jeff Hermes plagiarized his paper, unquote. Okay? And Jeff's unhappy and he sues. Now, first of all, who is he going to sue? Is he going to sue Natalie, who now has been named as saying it? Or is he going to sue my newspaper? And the answer is probably he'll sue both. But if he's going to choose, he's going to sue me because the newspaper typically, even today, has deeper pockets than an individual. Although, you know, a very outstanding Chicago lawyer, it might not be true.
Plus, after my heists.
Yeah, right, you're $12,000, you know, right. That's right. So, assuming Jeff sues the newspaper, what's my defense? My defense is that it's true. All I put in the paper is that Natalie Spears said, quote, Jeff is a plagiarist. And that's exactly what she said. So my quote was accurate. It was a true statement because Natalie said it. And I named Natalie so we don't have to deal with anonymous sources and the like. So I should be able to defend on truth, right? And the answer is wrong. That's not right. That I am responsible for republishing her quote. And therefore, I'm responsible for the underlying truth of that quote because I put it in my newspaper, I put it in my blog. I'm responsible for it as if I had reported it myself. I can't get off on the fact that, well, she said it, so therefore it's okay. By the way, if you think about it, that makes perfect sense because A, I've distributed it to the world, whether she just distributed it to me as a newspaper reporter. And secondly, you could libel anyone if this wasn't the rule, because you could always find someone to say something terrible about people, and then you'd always be protected.
I think this one is an important one to bring home, because a lot of times people don't realize, even if it's an authoritative person who says something, we defended a case here that was brought by Bo Jackson against California newspapers, who had published a statement at a sports conference that was made by someone purporting to have knowledge that he allegedly, this is what was reported, had suffered a hip injury due to steroids. And he felt extremely strongly that was not true and sued the newspapers over it. And, you know, as a first instance, you might say, well, it was a well-known professional sports psychologist, I forget, it was some sort of physician of some kind, or somebody who spoke out about athletes and their conditions, so that person could be trusted. But as George just said, it doesn't matter. If you put it in your newspaper, you're responsible for the truth of the statement.
There's a trap which can come up in these cases, because if you get sued based on what your source said, what are you going to do? You're probably going to go to your source and say, hey, I've been sued, we need you to back up the truth of this. Now, there is a trap that can come into play here, because take the example which George just gave of Natalie saying scurrilous things about me. Who am I going to sue? George said, well, yes, I'll probably sue the paper eventually, because that's where the money is. But one thing that does happen is I might sue Natalie first, knowing that she can't defend, or that she won't have the money to pay a judgment. And instead what might happen is I'll try to settle with Natalie and obtain from her a cooperation agreement to help me go after George. This is a way in which clever libel plaintiffs have actually turned sources against the media outlets and used them as a tool in litigation. So this is an important piece to be aware of, that sometimes your source can be sued first and then the media outlet gets sued after a settlement is obtained with the source.
Now, there are two things I'm going to talk about that to some degree vitiate what we just said. First of all, there are two exceptions to this rule. And third, there should be another exception, but there isn't, that we'll discuss, because that kind of comes up a lot. So what are the two exceptions to what otherwise seems a harsh rule that if you republish something, even though it's correct, you still can get sued for it? The underlying facts are wrong. Which means really that if you get a quote, I have to check it out the way I would check out anything based on my own reporting. I mean, that's the bottom line. Obviously, it doesn't mean you can never put in someone's quote. Obviously, you can. But you have to be as confident of it and verify it and get factual support for it the way you would for reporting that your own reporter just kind of found without the direct quote. What are the two exceptions? The first exception makes a lot of sense. And that is that if the quote comes from an official proceeding, an official meeting, a Senate committee meeting, a Senate floor, a city council meeting, Board of Education meeting, a courtroom, a trial, a deposition, court papers, the president's executive order. If it comes from any sort of official proceeding, official document, official meeting, then we're protected. And as long as we quote it fairly and accurately, or even summarize it, don't have to quote it, summarize it fairly and accurately, we're protected. Now, why is that? And the reason is really fairly simple. The reason is that if I were to ask you what is the main mission of the press, you would probably say we're supposed to be the watchdog over government, right? We're there to make sure government doesn't abuse its powers, and we're a check on government and so on. But there's a second mission that also exists, which is that the public can't all go to Washington and sit in the Senate committee meeting. But yet it's our duty, it's our mission as well, to be a proxy for the public and let them know what's going on, what government is up to. And we can't really report on what's going on in government, what government's up to, unless we're allowed to report what really goes on in these official meetings. Which is why this privilege is limited to official meetings. It doesn't include interviews. It, for the most part, doesn't even include press conferences, because those aren't official. But anything that's an official government meeting or document, the public is supposed to know about it, and we're the carrier that's supposed to tell them, and therefore we're protected if we report it fairly and accurately. So
sometimes press conferences, because there is some law here in Illinois, if it's, for example, by the head of the police department, for example, would come within this protection as well.
And if that's true, that may be true in Illinois, and not necessarily true in other states. So that's where you start getting a little variation among the states. Generally, libel law is pretty much the same, but there are little tiny nuances that come up, of which this is a good example. The second exception is very relevant to you all in the internet business, and in my view, and you might disagree with me, is of questionable validity today, but I want to say how it came about. So in 1993 or so, the very onset of the internet. Someone wrote a defamatory post to a website, and that website owner had a monitor who was supposed to review all the posts before they were put on the website that came from readers from the outside. The monitor fell down on the job. This defamatory post was published, and the victim sued. Went to court, and the judge said, well, there's this guy who's supposed to be reviewing these things. He was negligent. He let this go by. There's negligence. That's all I really have to find, and therefore the website owner is liable for libel and has to pay damages. Okay? The next year, same situation comes up, except in the second case, the company doesn't employ a monitor. The stuff goes on to the website automatically without anyone filtering it, right? Goes to court again. The judge looks at the prior decision and says, well, there's no negligence here. There was no one reviewing it, so there was no negligence on the part of the website. Therefore, no negligence, no liability. So if you're met with those two decisions and you're a website owner, are you going to have a monitor or not? Well, you're not going to have a monitor because A, why pay an extra employee? And B, why pay an extra employee who's going to enhance and make it more likely that you're going to lose cases? That doesn't really make a lot of sense. And yet good public policy would dictate that we like monitors, because why shouldn't companies pay for monitors to make sure that, you know, indecent and terrible things don't get on the internet? So Congress stepped into the breach in their infinite wisdom and said, okay, we're going to settle this. There's going to be no liability at all. Whether you have a monitor or don't have a monitor, there's going to be no liability for a website owner for a third-party post. Now, that doesn't mean that you can't have liability if it's your own blogger who you pay, your own employee or contractor who you pay to write an article. Then you're just still responsible. But if it comes from a third party, which you have no links to, and it goes on pretty much unchanged onto your website, whether or not you have someone monitoring or filtering, it doesn't matter. The website owner is immune from liability. And the reason was, one, to kind of fix the incongruity of the two cases I mentioned, and the other was that in 1996, when the Congress passed this in so-called Communications Decency Act, Section 230, which is a very important section, it was done with a policy initiative or point to enhance speech on the internet. The more speech on the internet, the better. And so this was kind of motivated to do just that. Today, you could argue, I don't think we need that sort of motivation. There's plenty of speech on the internet as things stand without really having the Congress having to step in. But this is so ingrained now in us that it would be very hard to roll the clock back. I mean, what would happen if 230 were repealed? Essentially, I mean, for starters, Facebook and Twitter would go out of business. They couldn't really survive a regime where 230 didn't exist, which is why it's very unlikely that there'll be change. But from a public policy point of view, you know, one wonders. Yeah.
How does this recent sex trafficking thing play into that? You know what I'm talking about?
Yeah.
Craigslist and some of them had to.
Yeah, that's a very good question, Jeff.
Sure. This is something I've been following. You're talking about FOSTA. It's a federal statute which actually did change Section 230, but in a very limited respect, specifically for online sites that were hosting content that facilitates certain kinds of sex trafficking. And it allowed federal claims, it expanded the kinds of federal claims for sex trafficking which could be asserted against platforms which knowingly facilitate that kind of activity, but there is a knowingness qualification to the statute, and opened up certain kinds of state liability which didn't exist before. So there are exceptions to Section 230, like this exception for sex trafficking. There's another one which is very important, which we'll talk about more in the copyright section, which has to do with intellectual property law. Intellectual property claims are not covered by Section 230. So if a poster to your site posts copyright infringing material, there's potential for you to be liable for it. Section 230 does not help. Other violations of federal criminal law. people posting child pornography to your site violates federal criminal law. Section 230's immunity doesn't apply. If you become aware of that kind of stuff on your site, you are responsible not only for taking it down immediately, but also informing the federal authorities. So there are exceptions to this, but for the vast majority of your basic content liability claims, defamation, invasion of privacy, infliction of emotional distress, those kinds of claims, Section 230 provides very broad protection without, and sort of regardless of whether you know about it or not. You can know that somebody is posting defamatory material to your website, but so long as you weren't involved in its creation or modification to make it defamatory, you have immunity.
So, yeah, can you talk about corrections and how they factor into?
Get there in a couple of minutes, okay? All right, so those are the two exceptions. Now, what Natalie started talking about when she talked about a press conference by the police chief, what happens when, let's say, I don't want to say President Trump because everyone goes crazy, but let's say is Rahm Emanuel still the mayor of Chicago, or am I a year too late?
No, right now he is.
He is.
Not running for re-election.
So let's say that Senator Durbin says that Rahm Emanuel takes bribes. And let's say that the mayor of Chicago says, I don't take bribes, but that goddamn Senator Durbin molested 5 teenagers last month. And you hear both these quotes. Do you publish them or not? Let's say you have the quotes accurately, but you really don't believe either charge. You followed both these politicians and you really don't believe it. What do? From a journalism point of view, there's no question but that you run the story because it's newsworthy that they're making these charges and countercharges against each other. From a pure legal point of view, it's a disaster because not only are you printing something that's false, you know that it's false. And if you do a good job with your reader, you're going to tell the reader in the first paragraph, we don't really believe this. Or what you do is the old formula of you have 5 quotes that undercut the truth of it and that make pretty clear that you're telling the reader, don't believe this, but this is what this cretin said. And you should know that because he's a public official and he's making these totally unwarranted charges. So I always found this to be one of the 2 most difficult decisions I had when I was vetting stories. Because on the one hand, it's clearly newsworthy, but on the other, I'm a lawyer, and I got to say, but if we get sued, we're in big trouble because this is one of the very few places. Usually good journalism and good law are parallel. They're similar. But this is one of the places where good journalism and good law really kind of separate. And I said always, that you should run the story and I'll convince a judge that the law doesn't make any sense. Fortunately, the Times never got sued in an instance like that, but the Pennsylvania paper did in a race for town council between 2 people, and one of them said just the most terrible things about the other guy. The victim sued. The victim won the election. So in other words, all these statements, which the paper suggested were all untrue and were hokey, the readers got, and the readers voted against the guy who made the statements. So the guy who made the statements lost the election, but nonetheless was sued by the winner of the election, and he settled. But the winner of the election also sued the paper, which did the right thing journalistically because the right guy won the election. The case went to the Supreme Court of Pennsylvania, which said, I think inexplicably, but which said, despite the fact that they're a good lawyer, and despite my theory, will explain this to a judge, said, hey, paper published something, it was false, they knew it was false, they published anyhow, that's exactly what the law doesn't allow, so therefore there's liability, and therefore the paper had to settle, which I've always called the worst decision in American libel law in the last 30 years, because it just totally makes no sense at all in terms of what journalists are supposed to do. But that's the status of the law.
What's the name of the case?
Oh, people always ask me on Norton v. We go through this every time. I talk about this case. Everyone says, "What's the name?" And I always forget. Norton v. someone.
Green, something like that.
Yeah, it's with a G, yes. Anyhow, we'll get it for you in a second.
Sorry.
Okay, so that's the republication theory. The next theory, next element, fourth element, is that it has to be defamatory. What does that mean? If Natalie's newspaper writes an article and they call me George B. Freeman and my initial is H, and I'm George H. Freeman, can I sue for libel? The answer is no, because that has no effect on my reputation, right? It has to be false, but it also has to be damaging to my reputation. And basically that means, you know, is my reputation going to suffer? Are people going to not be my friend? Are people going to turn away from me? People think less of me than they did before. It's a definition that's hard to really quantify, and it moves the way culture moves. So in the 1920s, to falsely say that someone was black when in fact they were white was defamatory. Yeah, Norton v. Glenn, I knew it was a G, sorry.
2004.
2004 in Pennsylvania. In the 1950s, to say someone was a communist was defamatory, but that's no longer defamatory today. You can't say, well, he's a Republican when in fact he's a Democrat and that lowers his reputation. It might in some circles, but that's not enough to carry a defamation suit. The issue that's more hotly debated today along the same lines is, what if you call someone gay who's not gay? Now, put aside privacy, which we'll talk about in a few minutes, and just forget about that, okay? Because maybe it's an invasion of privacy to talk about their sexual persuasion at all in the first place. But now I'm talking about libel, and let's say you're not gay, but you're called gay. Is that libelous? And you won't be totally surprised to learn that the answer depends on what? Huh? Where you are. In the blue states, those courts generally, I mean not as a rule, but generally, say, oh no, it's not defamatory, we respect everyone, it doesn't matter, it's not defamatory, your reputation won't go down in New York City because you're called gay when you're not gay. But boy, in Utah or Mississippi, the courts say, wow, geez, that is defamatory. You know, if you're in the firehouse, the firemen, your colleagues are going to not want to go out on the same trips as you. If you're in the faculty room, teachers are not going to want to have lunch with you. If you're on the schoolyard, you'll get bullied and beaten up. So it does have an effect. And, you know, 20 years ago, I think I actually asked this question at a conference and had two really good lawyers argue it out. And, you know, the liberal First Amendment lawyers said, oh, we all respect each other, there are anti-discrimination laws. And the other lawyer, who was a plaintiff's lawyer, said, you know, that's all limousine liberal gobbledygook, but, you know, in the schoolyard or in the firehouse, it really matters. And I asked for a vote among the libel lawyers in the room, and 80% agreed that it was libelous, that the plaintiff's lawyer carried the day. I think that would be different today, because we've moved ahead in the last 15 years, and 15 years from now, my guess is it wouldn't even be a question. It's just like calling someone a communist, you know, 50 years ago. But that's just an example that these things, you know, kind of depend in part on what the mores of the community are. Okay, so it has to be defamatory. And the final element is that it has to cause damage. Now, the most important thing to understand about damage is that that damage doesn't have to be financial damage. Okay, you don't have to, the plaintiff doesn't have to go into court and show, I lost my job, I had to go to a shrink, I had to pay the bills. It's not something that can be quantitized monetarily. You can just say, just like you do if you're injured and you don't have hospital bills, you have nothing, but you have pain and suffering. You know, it hurt me, I got headaches, whatever. In libel, if it caused reputational damage and you just sense that people think less of you, and you can put up one witness who says, yes, I did think less of you, that's damage right there. And then it's totally up to the jury whether that one person who claims, yeah, I think less of you, or 10 people, or 1,000 people, whether that's worth $1 $1,000, $100,000, or $100 million. It's totally up to the jury, which is why so many cases settle, because one could say, you know, that's a screwed up system. You know, we leave this to the jury in this infinite range. But that's the way our system is. So the fact is, it's really important to understand that you don't have to quantify your damages. They don't have to be out-of-pocket expenses. They're so-called general or reputational damages, and that is totally up to the jury as to what they are, as long as you can put one person on the stand who says, yeah, I think less of them. I had a case once, and as I said, the time's never lost. But this case, we lost on every single element, because this was a case where we wrote an article about, it was at the beginning of the internet again, and it was an article about how prescription drugs are sold over the internet. And the bulk of the article was about how they're sold over the internet without going through the procedures you're supposed to go through with doctors' prescriptions. But they're just ordered over the internet, and then you mail the drugs, and the transaction's completed, which was, I guess, somewhat illegal. And one of the pictures was of a website of a drugstore offering drugs to the public. But that drugstore actually offered it only if you sent in a doctor's prescription. But that wasn't visible on the internet screen that we showed. And so we lost on falsity, we lost on that it was defamatory, we lost on that it was negligent, we lost on that, you know, there wasn't a higher test than negligent because the drugstore was kind of a private figure, notwithstanding they advertised on the internet, which we argued. So we lost on everything. The only thing was that they couldn't find really any doctors who read our stupid article, and therefore no one didn't do business with them anymore. So they had no business losses, and the only reputational witness they put on was the owner's cousin. And so when the cousin was on the stand, we said, well, did you read this? So, yeah, I read it, and I couldn't believe it, because I know my cousin Bob is a very honest guy. And we said, oh, you couldn't believe it? No, I know he's a good guy. Well, so you didn't think less of him? No, I didn't believe the stupid article. Therefore, they showed no damages, and we won the case. You know, not terribly deservedly, but so you have to prove damages. Now, to go back to your earlier question, what's the effect of a correction? It's really important to understand that in all but 4 states, although one of the states is California, running a correction really doesn't very much help on the damage side. In other words, just because you run a correction, you can't say, well, therefore, it's been, you know, I've ameliorated the hurt, and therefore there should be no damages. In 4 states, one of which is California, the law is that if you run a correction, and if it's run quickly, and if it's run as visibly as the original article, then the correction, then the liability is limited. Damages are limited to your out-of-pocket losses. And you can't sue for general reputational damages, as I've just described. But in 46 of the states, that's not the case, and a retraction doesn't particularly help you on the damage side. It might keep away punitive damages, but punitive damages, which are even more than compensatory damages, are unusual, and so it's not something I'd terribly worry about. The question then is, well, is it a good thing or a bad thing to run retractions? And to me, at the Times, the answer was, our first duty is to our reader. We've got to square up with our reader and tell the truth as much as we can. And so therefore, regardless of the legal fallout, we're going to run retractions when we think we should. And I think that's clearly the right answer. But I also think that from a legal point of view, it's helpful to run retractions. People say, some lawyers say it's not, because you're admitting the error. And so you're allowing the plaintiff the evidence that the thing was false, you know, right off the bat. But in my view, if we're prepared to run a retraction, it's going to be pretty easy for the plaintiff to prove the thing was false, because we know the thing's false ourselves. So how hard is it going to be for them to prove it? Not very. And so really that part of it is that, oh, we're giving, you know, this evidence and this argument up, you know, I think is kind of a moot point. On the other hand, Americans love people who admit errors, who are not defensive about it. And I think you get points with the judge and the jury if you admit your error, if you say you ran a correction, and therefore the damage will be less because they'll like you more, and that's what juries are about. I can give you one example that I think is a great example. This was in Buffalo at a radio station. And there was some sort of mob rub-out of a leading restaurateur in Buffalo. And the radio station was all excited about this, and they wanted to put it on the air right away. The only problem was they didn't know who the guy was who was rubbed out. They asked around the newsroom, and they said, well, I think it's the biggest restaurateur in town, and the guy who owns the biggest steakhouse is Bob Smith, so I think it's Bob Smith. So the reporter says, well, let's check it out. I'll go to call the FBI. So they call the FBI, and they say, you know, we know you're checking into this mob rub-out. We understand that the victim was Bob Smith. Is that right? And the FBI said, you know, we can't comment on pending investigations. We can't answer that question for you. And the reporter then, who must have just watched All the President's Men the night before on TV, says, well, I'll tell you what. If I'm right that it's Bob Smith, don't call me back. But if I'm wrong, then please call me back, because I want to know that I shouldn't go ahead with it. And the FBI guy says, well, I told you I can't really comment either way. Doesn't call back. The radio takes that as a confirmation and goes on the air saying Bob Smith was shot in this mafia rub-out. An hour or two later, Bob Smith calls. You know, what's wrong with you idiots? I'm very much alive. I had nothing to do with this. And now you've connected me somehow with the mob. And said that I'm dead. And so he eventually sued. And the case went to trial, and the radio station offered as a defense their retraction. And their retraction was pretty much like this. It said, yesterday we reported that Bob Smith was killed in a mafia rub-out. And then the next sentence was, the FBI confirmed this report, which was clearly not true, but our independent investigation has persuaded us that it wasn't Bob Smith, but it was someone else. What was the independent investigation? It was Bob calling them and saying, you idiots, you know, it's not me. And the jury was so upset about that very very kind of non-retraction retraction that they gave the plaintiff $16 million. Which is a lot when you consider that all that defamed him was by saying that he was dead, which he really wasn't. That's not all that defamatory, but I guess they connected him with the mob. But it's still, $16 million was for this, clearly for the bad correction that really wasn't a correction at all, or didn't admit guilt at all. And then the case got reversed on other reasons by the appellate court. There were bad jury instructions. And it got tried a second time to a different jury, no idea what happened the first time. Second jury, $16 million to the plaintiff, same result. So the lesson is, you know, if you're going to correct frontally, that, you know, really admit your error. Don't try to beat it out the bush, because the jury is going to beat you up for it. Yeah.
Can you argue that a person's reputation is so bad that they can't be defamed?
Yes. Yeah. An example of that was James Earl Ray, who before he killed Martin Luther King had, I think, kidnapped about 7 girls, raped 4 of them, and killed 2 of them. And Time magazine reported, after he had become famous, that he had kidnapped 12 girls and raped 8 of them and killed 3 of them. So, you know, they upped all the numbers. And James Earl Ray said, hey, it's a libel suit, that's all false. And they basically said, you have no reputation anyhow, so forget it. But it's not a defense that I think you're going to use very often. I mean, that's an extreme case. But in the normal case, it's going to be a tough defense to...
Some, as we talked about before, some states differ. So it can be less protected in certain parts of the country. So it's not a great one to rely on. But it can get you out of hot water, potentially.
There's a saying that even the reputation of a fiend may be impugned. So usually when you're talking about somebody who's libel-proof, you're really talking about somebody who has a long career history, is well known for doing these things. I defended a case in Massachusetts once involving somebody who was known within the prison system as being the worst offender in the system. Something along the lines of 5 or 6 aggravated rapes, various other run-ins with the police. Terrible, terrible human being. The court held that he was not libel-proof because despite the fact that he had done all of these things, his prior crimes had never been covered, and so his reputation had not been previously damaged. And so, you know, he was a horrible person, but nobody knew, and so his reputation was capable of being damaged by our publication.
No, but that's a good example of where reputation is important. That's why that's I mean, falsity and reputation are the two most important things in libel, really. So, let me end up the part about what the plaintiff has to prove by just telling you what the 3 trouble spots are. And I would say 90% of libel cases are brought for these 3 purposes, these 3 kind of situations. One we've already talked about, and that's the republication. And even editors at the Times always said, oh, you know, this person said it, so therefore I can repeat it in the paper. And that's just not true. So the whole republication doctrine is the first cause of many libel suits. The second, which is really important, is when you're relying solely on an anonymous source for the pejorative statements. So in other words, if you say an unnamed person in government says that there'll be an indictment of Natalie for rape tomorrow, and I put that in the paper, let's assume she never gets indicted, and she therefore sues me saying, hey, you know, I'm not a rapist, you know, I don't know where you came up with that. And I said, oh, I got it from a very reliable source. I got it from someone in government who said it was going to happen. And Natalie's going to say, what's your next question?
Who is the source?
Who's the source? Who told you that? A, because she wants to, you know, beat up the source. And B, because in terms of her libel case against me, she wants to know who it is that she can then argue that they're unreliable and I never should have listened to them and you know, all that sort of stuff. And meanwhile, I'm saying, well, I have a contract with this person. You know, we made an agreement that this person's confidential. So if you all are the juries, are you going to be on her side or my side? Juries are on her side. They've been in the courtroom for 2 weeks. Here's the most important question. Where did he get this news from? That's the very subject of the case. And I'm not telling you. And you're going to be pissed at me. And you're going to be very sympathetic to her. So this is not a case where by not revealing a source, you go to jail. This is a case where by not revealing a source, you're the defendant who's standing behind this unnamed source. And if you're not going to name them, they're not going to believe that you even have a source probably. And you're going to lose huge damages. So if you have an anonymous source making a pejorative statement about someone, the lawyer's lesson is use that source to get some on-the-record information, to get something more tangible that you can use and say, yeah, I have this, that's why I believe it. But if you don't do that, I'm not saying that news entities don't use that from time to time, but you should only do it if A, it's really, really important, and B, you know, you've thought about the risk and you're willing to take a risk. But it's a fairly easy suit by a plaintiff. If there's no other evidence that you have but this one source or 2 sources who insist on anonymity, you're willing to give them that anonymity even when you get sued, then you have nothing. I always tell my students, you're naked in court. You have nothing to show. And basically, even if the judge can say, jury, you can believe whatever you want. Judge can say, jury, you can believe whatever you want, including the fact that there is no source. Or what happened to me once when we represented the Boston Globe was that the judge said, there's liability. There's no even trial here on liability because they're guilty because they didn't say who the person was. The only thing for the jury to decide is damages, and the jury returned the verdict of $2 million against the Boston Globe under those circumstances. So that's the second trouble area. The third, which is really, I'd say half the lawsuits, is so-called libel by implication. And the most typical libel by implication is the mayor didn't beat his wife last night. So you put that in the paper, the mayor sues, and you say, hey, it's true. The mayor didn't beat his wife last night. But the implication is that the mayor beats his wife on many other nights, and so therefore you're going to have trouble. We had a lawsuit, I don't know if any of you remember a quarterback by the name of Ken Stabler. Yeah. Ken Stabler was a very greasy, kind of sleazy guy, I can say that because he's dead, and you can't libel the dead, which we'll get to in a few minutes. And we wrote a long article about him, about he associated with gamblers. And while that's not a crime, it was again against NFL rules. And way down in the story, we wrote that when Stabler came to New York to play against the Jets, he hung out with this gambler till 6 in the morning. And the next sentence was, in the game against the Jets the next day, he threw 5 interceptions and his team lost. And he sued, saying the juxtaposition of those two sentences indicated not only that he hung out with a gambler, which was true, but that he fixed the game. That's why we had those two sentences next to each other. And that seemed like a kind of frightening lawsuit. My boss, in fact, said, well, he met with the gambler many other times, didn't he? And I said, yeah. And she said, well, how come you didn't put the results of those games in the paper in the next sentence, that maybe he won the game? And I couldn't really answer that question. So it was a difficult lawsuit. We went down to Houston, where Stabler had retired to, and took his deposition. And his deposition, he said he never gambled. His mommy and pappy told him never to gamble, which was patently untrue. I mean, the guy was really a terrible guy. But then at the end of the deposition, we told him it was going to go on for a second day. And I could hear him in the back room screaming at his lawyers that he wasn't going to spend another hour, much less a day, with those goddamn lawyers from New York. And by the way, he didn't want to spend any more time with his own lawyers either. He hated lawyers. And he was trying to get a job as a broadcaster, and his agent told him, you're really not going to have too much luck getting a job if you're suing the New York Times. So he withdrew the suit the next day. So we've never lost, but we had cases that, we were lucky to win. But that's a good example of libel by implication. Another one was Wayne Newton. You all know Wayne Newton, the Las Vegas crooner. On the NBC Nightly News, they talked about Wayne Newton was building and financing a new Las Vegas casino. And the next sentence was that Wayne Newton was getting help from the mob. Now, the help from the mob actually dealt with his kids who had been, I think he was afraid they were going to be kidnapped, and so the mob was basically providing security for his kids. But if you're kind of making dinner at 6:30 and you hear on the news he's building a new hotel and he's seeking help from the mob, it sounds like his hotel and casino is going to be mob financed. So he sued for libel. And it was a very difficult libel case because it was in Las Vegas. And to get to the courthouse, you had to go down Wayne Newton Avenue. And in the middle of trial, there was a day off because it was a Wayne Newton holiday in Las Vegas. So you could see which way the local jury might have tilted. And he won a $17 million verdict against NBC, which fortunately for NBC was reversed on appeal because of lack of actual malice, which we'll get to in a couple minutes. But the point is that the juxtaposition of sentences, or in some cases of a photo and a caption and text, can really lead to implications that you don't mean, either because you're careless and a copy editor doesn't catch it, as happened in these cases, or sometimes because you're trying to actually get something through the back door and you want to suggest it to the reader, but you don't have proof of it, so you kind of can establish it just to sleaze it in there. And that's a very, very bad strategy. Yeah?
Question. I have a few online sites in North Seattle, and we're an online news partner of the Seattle Times, which basically allows us to run the first few paragraphs of the story and link to the whole story. Something related to maybe our communities. And if somebody complains that a Times story has something in it that is libelous, by running the 3 paragraphs or whatever and linking back to the Times story, could they come to us and get us for the same mistake?
I would say yes, because you're kind of republishing what they printed. The only thing that would help you and put you in a better position than the Times is that you could say you rely on the Times, and they're the Seattle Times, and you have a right to do that. So, for example, I'll get to it in a second, but if you're writing about a public person, and you have to prove that person has to prove that you had serious doubts as to the truth, you could say, well, I had no serious doubts of the truth because the Seattle Times wouldn't have printed it if they thought it was false. So I was fully confident it was right. If it's about a private figure, then it's maybe a little more touchy. But ultimately, you are responsible, but you will have defenses given to you. The one thing I don't usually mention, but it's worth mentioning given this question, is that strangely, that's the rule if it comes out of the Seattle Times. If, on the other hand, you got the story from the AP, you're allowed to publish. There's a so-called
Wire
service defense. And so if it's a wire service, the theory is you can't be around the world. That's why we have wire services. So you're allowed to just pick that up and use it automatically. I always had this problem really at the Times, especially someone mentioned the steroids. Natalie mentioned steroids. And every day, it was actually interesting. I don't know how many you read the Times, but the guy who was in the sports department covering steroids was a young reporter, rookie reporter named Michael Schmidt, who now is reporting on Trump every day and has, has broken a lot of stories on what's going on in the White House. But at that point, he was basically just covering steroids. And a lot of times, he didn't have the story himself, but he said the Dallas News reported that this Dallas athlete is on steroids. And the question was, well, can we just go ahead with it without any reporting on our own just because the Dallas News said so? And I ended up with what really was kind of an unsatisfactory rule, is that it depends on the paper. Dallas News probably okay, but the Topeka Star maybe not okay. And that's really not a very good legal grounding of a decision. But that's kind of what, I came up with, which I don't know, would you do any better than that?
No, but when we get to public figure and actually,
Yeah.
I'll give you an example that might be one to think about. Just that's part of what your everyday.
But it's a very good question because that happens more and more, where it's news, so you can't help but printing it because everyone else is talking about it, but you haven't done any other work. So what are you going to do? And that's a very good question. All right, so those are, did you agree?
I'm just curious if can newsroom resources or lack of newsroom resources be used to determine negligence and value of if somebody's not hiring a copy editor or all the resources that typically go into publication. Are they then more
Well, I mean, like if you don't have the monitor in that case, I don't think it's negligent. They're not going to criticize you for how you, proportion your staff. But I think, you can't really plead, well, I didn't have a copy editor because I couldn't afford it, so therefore it's okay that I was negligent. I mean, I don't think that's going to fly.
We're talking about public figures. There might be something to not having the resources, not believing that it was false because somebody,
Right.
But in a private figure plaintiff situation.
Yeah. You're absolutely right. I mean, I actually, the only place at the Times that had fact checkers was on the Times Magazine. And I actually thought legally it was a disadvantage to have fact checkers for exactly that reason, because then, if they made a mistake, you say, well, you had these people, what else are they supposed to do? Because you don't know those people, you could say, well, we didn't ever think of this problem, we never checked it. It's not great journalism, and it's not really a great argument, but sometimes it might work. Let me, we've spent a lot of time, let me go to the defenses quite quickly. The defenses for, that existed all along, right? Two of the most important we've already discussed. One is a fair and accurate report of an official proceeding, talked about that. And the other is opinion, and we talked about that some. The third, as I mentioned, is death. You can't libel dead people because they suffer no reputational harm because they don't know their reputation has been wounded because they're under the ground, right? And their estate can't sue for them because the estate didn't suffer the reputational damage, the person did. The only difference is that if you get libeled while you're alive and then you die, then the estate can still sue as an asset because the guy, the person who eventually died did suffer some pain while he was alive, and the estate therefore can bring the case. The only problem is the estate's not going to have a star witness because the star witness will no longer be around when you get the trial. But that's the rule. And then we talked about substantial truth. And then the last defense, which is really not much of a defense in most states, only Florida really recognizes it, and a few other states, is something called neutral reportage, which is the example I gave of the Pennsylvania case, where two important responsible figures are making charges and countercharges, and you report it neutrally. And that's what I think should be a defense, but in almost every state it's not been recognized, and it's been rejected. So I wish I could say that that is a defense, but it really isn't. Now, so those are the common law defenses. But in 1964, what happened is that the civil rights movement placed an ad in the New York Times. And for the time being, forget about it, that it's an ad, because that really doesn't change the legal dynamics of the story. And the ad consisted of a lot of criticism of the police in Montgomery, Alabama, who the ad said were abusing and beating up the blacks and the civil rights workers who were working for civil rights in the South. And the police commissioner wasn't named, but he was the head of the police department that was being criticized in the ad, and he sued. Now, the first question I would ask is, why did he sue? And really, the answer of that is what drives this entire case. Why do most people sue for libel? Money and reputation, right? In this case, the police commissioner sued for neither of those two reasons. Anyone want to guess why the police commissioner sued? The police commissioner sued because he was part of the Southern segregationist establishment. And what did they want vis-a-vis the northern media that was reporting on what was going on in the South?
Wanted to stop.
They wanted it to get out of the South so they wouldn't be reporting. And so what their strategy was to sue the northern media and hope that the media would realize they're going to lose all these cases and then get out of the South and not report on it. And that way they could continue abusing the blacks and the civil rights workers. Where if the New York, and they were only like 7 or so national media at that point. There was the Times, there was the Wall Street Journal, Washington Post was a local paper back then. There was AP and UPI, and there were 3 TV networks. And obviously there was no Fox, no cable, no nothing. So if you could get those 6 or 7 national news entities out of the South, feel that there was too much jeopardy in reporting on the abuses that were heaped on these people, then they could continue abusing them forever because public opinion was never going to come down on them. So they sued the Times, and they won $500,000 in this suit. And there were 8 other similar suits, so the Times was really losing $4 million, which was more than the profits they made in that year. And in fact, there were memos telling the reporters to get out of Alabama, which the reporters ignored because they thought the story was too big. The case got appealed, affirmed by the mid-level Alabama court, and affirmed by the Supreme Court of Alabama. And frankly, those decisions probably were proper under prevailing law because there were some falsities in the ad. There was exaggerations. So the case goes to the U.S. Supreme Court. And the U.S. Supreme Court, which at that time was a very liberal Warren court, said, we can't really allow this. And what the Times argued was that in the 1790s, the country passed the so-called Sedition Act, which said that it was a crime to say bad things about governments. And they passed that because that was a copy of essentially the same law that was in England that said it's a crime to say bad things about the king or the queen, right? Now, without getting into the history, you might say it's a little weird that we fought a revolution and then we copied the very laws we'd been revolting against. But that is actually what happened. And then a few years later, we kind of came to our senses and realized that that made no sense, and we repealed the Sedition Act. And so the Times lawyers argued that if you combine the First Amendment and the idea of free speech and debate on public issues, and the repeal of the Sedition Act, which meant that we encourage criticism of government, this is a government by the people, other people, for the people, rather than say it's illegal to criticize government, all that means that government shouldn't be able to sue for libel and scare the press into reporting on government, but the opposite should be true. We should have an incentive to report on government. That's what our history tells us and teaches us. So the court basically bought that argument and therefore said that when you're dealing with public figures, dealing with governmental figures, just falsity shouldn't be enough. You need more than falsity. Because anyone can make a mistake, and we want to incentivize reporting, not scare people from reporting. And so what you have to prove is so-called actual malice, which is a bad term. It's kind of misleading. But what it means is that the plaintiff has to prove that the press went ahead with serious doubts as to the truth. serious doubts as to the truth or a conscious awareness of the probable falsity of what you're writing about. Conscious awareness of probable falsity. Now that's a really, really hard test, because it really means that the press was either lying or close to lying, right? But it was intentionally a hard test because, as Justice Brennan wrote, we're committed, there's a national commitment to wide open, uninhibited, and robust debate on public issues, and that to have that, we have to give incentives to writing on it. So if you're 98% sure that the city council has committed bribery, but has been guilty of bribery, but you don't have that last bit of proof, that shouldn't be enough to inhibit you from running the story if you're confident in good faith that you are right. And yet under prior law, you could still maybe lose such a case, but under this new test, you were going to win it, and that's what that's what the court thought should be the case. So they changed the law and said under the First Amendment, you have to prove fault, and that fault in the case of a public official and then expanded to public figure is having serious doubts as to the truth. A very, very harsh test. And 10 years later, there was another case where they said as to a private figure, you or me, there has to be also fault, but that's a lesser degree of fault, but you have to at least prove negligence. And negligence means you didn't act like a professional, reasonable, responsible journalist. Did you get the right documents? Did you read them properly? Did you go to the right sources? Did you check if they were reliable or not reliable? All the steps that a good journalist would take. And so that's made it much harder. That's given extra protection for the press, particularly with public figures and public officials, but also to a lesser degree with private figures in creating the so-called false standard. That's an additional element that the plaintiff has to prove, which again has been rejected in the rest of the world, even in our British, Commonwealth friendly nations like Canada, England, Australia. They've all rejected that as being too protective and not giving individuals enough right to have recompense when false and damaging statements are made about them. How do you ever prove a libel case then? I mean, if I libeled Natalie and she sues me, she's going to ask at some point, well, did you believe the story to be true? And I'm going to say, because I'm not an idiot, I'm going to say, of course I did, yes. So if I say that, how can she ever prove that I had serious doubts as to the truth when I say I had no serious doubts as to the truth? And the answer is it's going to be really hard for her, but she's entitled to get all my notes, all my emails, all my drafts, all my interview notes, and maybe through all that stuff, which you're going to have to give up if you get sued, the plaintiff can make out some sort of circumstantial case that I did have doubts. Why did you change the draft from this to this? Why do you have an explanation point in the word scumbag when such and such was being said by a source? That showed that you had a pre-existing bias and you had a motivation to make up stuff about them. But it's very, very hard, but it's possible. But that's, I think, kind of the game that gets played.
Yeah.
Right?
And the same protection beyond just public officials, which is the New York Times v. Sullivan case, extends to public figures as well. And so somebody who just has so much notoriety among the public and access to the media themselves that they too should be treated with the same level of proof that they have to prove it from malice. So the person who asked the question left, but I was going to give an example of a situation where just taking the first few paragraphs of a very reputable source can be problematic if you then also report further on it. There was a case here in Chicago against the Tribune by a former NBA basketball player, Eddie Johnson. And it was a tale of two Eddies. There were two Eddie Johnsons in the NBA. Let's just say the good Eddie, who's here from Illinois, and the bad Eddie. And there was a AP story that ran that talked about in the first three graphs, as it is front-loaded, right, that the bad Eddie, had been arrested and I forget what the crime was, but of some crime. And late at night, right before deadlines, the reporter and editor saw that, someone deduced that it must be the Illinois-related Eddie. It was Illinois, but he had studied at the University of Illinois and played basketball there as well, and wrote, in addition to the first few graphs, that it was also the relation to the Illinois Eddie, because the Illinois Eddie. So of course, they ran a retraction the next day when, just like the example George gave, the good Eddie called and said, hey, that's not me. And a robust retraction, and obviously it was just wrong. But the question, was that Eddie Johnson, the former NBA player and now broadcaster, a public figure, and if so, was it actual malice? I mean, they thought that was what was in the AP story. It was definitely, at the time that they published it, something they believed was true. And lo and behold, the court upheld that it was not actual malice. And so while it was false, while there was a retraction, because Eddie Johnson was a public figure, they were absolved of any liability. And that went up on appeal and was affirmed, and then the Supreme Court didn't take it up, probably because it's pretty obvious that it's a public figure. But that's just a tale in terms of relying on other reporting and then reporting further on it.
Two things. I mean, I have a couple of questions. But before that, the last thing I'd say, and then we should really get to privacy, is that on the one hand, as Natalie just said, a lot of times cases really will rise or fall on whether the plaintiff is ruled a public figure or not, because the standards are so different, as we've just explained. But on the other hand, it's really, really important for journalists not to be thinking about that. I mean, it's just really, really bad for a journalist to say, well, this is a public figure, so therefore I can be negligent. It doesn't really matter. As long as I don't have any serious doubts, I should be okay. I mean, that, first of all, totally is derelict to your journalistic duty to really get the story right. And second of all, you shouldn't be clouding your thoughts with all this legal gibberish that we're talking about. If you get sued, then we're going to use all the legal things we can. But you really can't be thinking in your head, well, it's a public figure, so I can afford to be sloppy. That's not a really career-enhancing move. You had a question?
Yes. Can you expand on the culpability or not that the newspaper has for an ad that is placed that makes false statements?
Yeah. Generally speaking, Sullivan was an ad, which is just an odd kind of quirk of history. Generally speaking, an ad, even dealing with a private figure, the paper has to have known that the thing was false. So if you just run an ad and no one really looks at it, no one reads it carefully, it just goes in the paper, you're generally speaking not going to be responsible. Really, really rare that you're going to be responsible. We had Times had an advertising acceptability department, and they actually read carefully opinion ads, ads that were about politics or about social campaign. And that maybe put a higher burden on us, because we actually had a guy who read it. But still, it's really rare that you're going to be. It's not the same standard as though you wrote it yourself. Let's just go on. Yeah.
What is the current thinking on the wisdom or lack thereof of reporters destroying their notes and records post-publication?
Lawyers disagree on that.
Different views.
We all have different views. My view is that the default should be getting rid of notes rather than keeping them, but that you should keep notes that you think journalistically will have some meaning to you.
Or you want to write a book someday.
You want to write a book someday. And also, I find it's good to keep notes on investigative, big pieces where you have a lot of evidence, and in the end, if the plaintiff sues, it's nice to have all that evidence available. There have been 2 cases that I got rid of by just throwing the notes at the plaintiff's lawyer right at the first day. And he sees how much stuff I have on this guy that we didn't even put in the paper, and they give up. On the other hand, in a short story, day-to-day story that's not going to be ongoing, you can get subpoenaed for those notes, and then we have to deal with that. If you don't have notes, you might not have much memory, then the subpoenas go away automatically. So I wouldn't keep everything, but it's, some people say, well, whatever you do it, consistently, and I don't subscribe to that, because I don't do that with my pieces of paper. They're very happy when the Times moved offices, because then everyone got rid of everything, and we kind of started all over again on a blank slate, and no one had any documents, and that was, I felt that was helpful. But sometimes they are helpful in defending a libel suit. What do you think, Natalie? You have a different view?
You know, I generally have more of the view that if you're going to have a certain practice, to do it consistently, because I have been involved in situations where there's lots of questions as to when something was thrown out and why, and I think it is just healthy to have sort of a consistent practice, even if it's nuanced, and for certain stories investigative, you keep it. The other thing that I've heard some people subscribe to is most states have a pretty short statute of limitations for libel, 1 year, and so after 1 year, you know, maybe that is a good time to consider if you're not using it, don't anticipate using it, not keeping it. So.
All right. Yeah, last question, and we go to privacy.
We're in a relatively small city, and so everybody knows everybody. And we did a report on a problem with the way the city is managing construction, namely that they're not doing the proper fire reviews of large construction projects that are supposed to be getting done. And the city manager, voted on by, I think, one of our elected officials, got really upset with our reporting and published a letter at the city website denouncing our reporting, claiming it was false. Our reporting isn't false. I've been through tons of lawyers on this legal question in terms of the fire code. I've called the state of Michigan. I mean, I've been through the whole thing. I've documented everything. We're right. One of my readers actually said to us, you guys should sue the city attorney for libel, because he's specifically calling you out, namely me, because I was the reporter, individually, basically saying you're producing false news about the city when you're in fact not doing that. And that just struck me as so bizarre. And yet, I just wanted to ask you, do newspapers ever do that? Do they ever go back at city officials and say, you have no right to call us liars?
Well, let me answer that two ways. One is that the Times never did that, but that might be not, a fair example, because A, they, were holier than thou, but B, also, they didn't like anyone to be a libel plaintiff. I mean, they didn't, because if we won, we might have been created bad law, for defendants, and good law for plaintiffs, which is not what you want to be doing generally. On the other hand, I think in today's atmosphere, if you have a slam dunk case where you can really show that it's true and that this guy was libeling you, I don't think it's a bad idea, because it might shut these people up. On the other hand, your case sounds a little complicated, and if it gets very nuanced, it's going to probably be more work and more uncertainty than you
Yeah,
really
I was
want to
not
take.
inclined to do it. This person was just very motivated by Trump, right? They felt like, here is a public official
that's-
calling the press a liar. Here's an opportunity at the local level
Yeah.
to say, you can't just
Yeah,
call us
no, I like
liars.
it. I like the
Yeah.
idea.
Can you write a column?
We
Yeah, that's
we
what I was gonna
specifically
say.
don't publish editorials. We sometimes explain our reporting, but we are very careful to try to be very nonpartisan because it's a small one-party town. We try very hard never to do that kind of thing. So we explain our reporting, but we try not to say,
But
we are
maybe-
outraged.
But when the
Maybe
newspaper,
that is a time for it, right? I mean, you have the power of the pen and that you
wouldn't
can.
the newspaper be looked upon as kind of a public figure? In the same
Well,
way?
certainly I would be a public
Yes.
figure.
Yeah, the newspaper.
Yes, but I mean, presumably she would say that the guy knew it was not true. He just was, politicizing it, right? Saying it for political reasons.
The sad thing is I think he believes it's true. He just have a crappy city manager.
Yeah. No, I'd be open to the idea. I kind of like it, but
Talking about
Maybe
with
slap a good weapon there.
anti-slap, potentially, if they have one in
That's it.
your state.
but they never sued. They never sued this way. So,
Oh, it's-
Yeah.
all right, why don't you go ahead?
So we're going to whiz through privacy. There are different forms of invasion of privacy claims, and we're just going to focus on the one that deals with publication, and that's publication of private facts. So we've been talking about false statements, and what this is about is even if you have an absolutely true statement, can you still be held liable for publishing that? Not for defamation, but for invasion of privacy, and the answer is yes. The claim that a plaintiff would make in the situation is called publication of private facts, and it has 4 basic elements, although there are variations from state to state, but 4 basic elements. Public disclosure, so again, similar we talked about publication. This is giving publicity to the statement in some way, in the newspaper, on the radio, in the broadcast. Clearly meets the test, as does the internet. Private fact, it's got to be a private fact. So we'll talk about that because that's pretty complicated. What is a private fact? There's obviously some bright lines, but then there's a whole lot of gray area in there. It's got to be not only a public disclosure of this private fact, but disclosing it, the act of disclosing this private fact has to be highly offensive to a reasonable person of ordinary sensibilities. So not just that it wasn't known before, but that the fact that it is now publicized is highly offensive to a reasonable person. We're going to break these down a little bit more. But, and then there's a defense to it, and that is that it's got to be something that's not a legitimate matter of public concern. So, in other words, even if you have something that is a private fact and that could potentially be highly offensive to a reasonable person, it could be trumped by the fact that it is newsworthy or of such legitimate public concern that you're able to publish it and you're protected by the law. That area is pretty narrow, so a lot of times people think, oh, but it's a matter of public concern, and that is not a wide lane, so that's something to be careful about. One of the cases that came up recently, did everyone follow or hear about the Hulk Hogan versus Gawker case? So in the interest of time, we won't spend a lot of time on it, and George, feel free to pipe up in this. I won't say that I'm an absolute student of this case, but the general facts obviously are that Gawker published a videotape of Hulk Hogan having sex with the wife of his then best friend. What was his name? Something like SpongeBob or something like Bubba the Love Sponge. And the defense, and one of the defenses to it was that it was a matter of public concern because of the way that the Hulk had portrayed himself in the public. And the court didn't buy that and basically found that it also was highly offensive to a reasonable person. And we all know what happened next, and that is Gawker went belly up. It doesn't exist. So the jury actually awarded it $140 million in damages over that.
Which put Eric out of business. There really were two defenses. One is, as Natalie says, is that Hulk, on radio interviews and in books, wrote about his supposedly great sexual conquests, and therefore he put this all out on the table, and therefore he can't be then allowed to sue for privacy after he himself has made it into kind of a public thing. And the Gawker made it very clever. They said, he can't be bragging about his sexual conquests and then basically say anyone who talks about it differently than he does is guilty of invasion of privacy, because then there's no check on what he has to say. He's closing off discussion just the way he wants to put it, and that can't be. So that was a pretty good argument. The other thing that I liked as an argument, which they kind of couldn't quite follow up on, was that the article that accompanied the sex tape basically started out that private people's sex is no different than celebrity sex. Everyone kind of has sex in the same tawdry way. You got to take your pants off one leg at a time, etc.
It's like the People magazine. Right?
But that's kind of an interesting concept, that here's a celebrity, but it's as whatever as everyday sex by non-interesting people. The problem was that was the first two paragraphs of the article, and that you could say is a reasonable social topic to write about. Unfortunately, the writer abandoned it after two paragraphs and then started essentially a play-by-play of the specifics that you see on the tape. And so he didn't really follow through on what I thought would have been a pretty good topic to say that this really was newsworthy. It was an interesting concept to kind of write about. In the end, we think, or many of us think, that the court ultimately on appeal would have granted one of those defenses, but Gawker didn't have the money to put up an appeal bond on and had to fold.
So what is a private fact, right? In the interest of time here, I'm going to kind of just give you some examples of cases that have been found to be private facts. HIV status, drug use, child abuse, medical conditions, adoption. I'm not saying every single one of these categorically, and I should say, since it's being recorded, and even for the first part of this, there are nuances in all of this, so a lot of the statements we've made in a certain case might, flip the other way. But generally, private economic affairs also, you're dealing with a public figure, that might be a little different, but private economic affairs. We even had a situation here in Illinois where it was reported on 5 sets of triplets were born on the same day at the same hospital, and the hospital thought this was a great publicity move and sent out to the press to come in, and the press came in to the neonatal unit and talked to some of the families and gave the last names of some of the babies that were born. And in one case, in one of the papers, reported that a certain set of the twins had been conceived through in vitro fertilization. Case settled, so not a decision as to whether or not that was private. But when you get into kids, I would say, sexual reproduction, certainly sex tapes, those are private. Might be a question of whether it's newsworthy. I don't know that the court would have thought that it was newsworthy enough to share that just because 5 sets of triplets were born on the same day at the same hospital, but that never got fully to decision. So another case here that's notable happened many years ago, but Green versus Chicago Tribune, where the reporters went into the hospital. This is unfortunately not terribly different than today. There was a lot of gang warfare, a lot of deaths, youth being killed as a result of gang violence, and one such youth was killed, and the reporters went in to the hospital where they were let in with permission, and then were taking photos of the dead teenager, and overheard and were asked to leave actually, but didn't, but overheard statements that the mother was making, sort of her last words to her child, and a decision was made that that was newsworthy because it really brought home the impact of gang violence, and the court did say it was not newsworthy enough. So something like gang violence and the horrible impact on families, you might think, oh, that enough in and of itself would make it newsworthy. But again, when you're dealing with children and a familial, private type of conversation, there's a real area of red flags to be concerned about. I have more examples here, but I think I'm just going to blow through. The other thing, I think the other important takeaway is consent. You may think somebody might have shared with you their, for example, HIV status or their drug use, and said it was totally okay to publish. And one question is, right before, then they tell you it's not. Can somebody withdraw consent? And oftentimes it's sort of a gray area, but I think it's pretty fair to say that if somebody has shared something only with you and then they tell you you can't use it, that's going to be perilous to proceed. But you may be able to find out that they've told other people that already, and it's really not a private fact. And so sometimes capturing things on the internet or in other public places where folks have said things may be helpful.
Can I say one thing on consent that you could maybe disagree with?
Yeah.
A lot of times you get the question having to do with kids, and kids, legally can't give consent, but you don't need consent even of a kid if the story is newsworthy. So a lot of times it's the dilemma, what do you do about that? You're interviewing a 16-year-old about smoking or drug use at the high school, my view is that you shouldn't ask for consent of the parents, because if you want to use this quote, you're going to want to use it anyhow. Consent will almost inevitably not be granted, and then if you go ahead and run it, they'll be doubly pissed because you asked for consent, they said no, and you ran it anyhow. You're better off not asking them in the first place if it's something that you think you're going to use anyhow. And with kids, it's important to realize that while if you're dealing with a 5-year-old, you probably should get consent no matter what, because courts are going to be very sympathetic to a young person, an old person, a decrepit person, a wounded person. But on the other hand, if you're a 14, 15, 16, 17-year-old, I wouldn't automatically think if it's newsworthy I have to go to the parents, because I think you get yourself into more trouble that way.
It's an area where if you're dealing with kids and you have access to lawyers to help you look at things in advance of publication, probably a good idea. So thank you for listening to us, and we'll stick around if you have more questions afterwards.
And if you, we'd like you to stay for the copyright session, which starts in 15 minutes, but if you're not, then if you could come up, and this takes 1 minute to fill out, a little evaluation would be helpful to us. Thank you.
Thank you.
Thank you. Thank you.